For those of us who've joined us in Napa before, you know the Beta SMB Institute Leaders Forum is special. It's a special location, a special venue, and best of all, special people. We pride ourselves on curating an A-list of attendees, the best and brightest leaders of our $500 billion plus business to small business marketplace. And every day we are adding speakers, workshops, and special events to this intimate forum, all of it highlighting the shared challenges and opportunities in a setting that drives casual and candid exchange. Join us at the 2022 Beta SMB Institute Leaders Forum, May 11th and 12th in Napa, California. Tickets are on sale now at betasmbi.com/leadersforum22. Good day, everybody. Dave Walker here with the Beta SMB Institute. And one of the things we wanted to bring to the Forward 22 event was really subject matter experts talking about topics that are in our future and maybe top of mind for some of you. One that I found very intriguing is just the subject of COVID-related litigation that potentially faces us as large enterprises who serve small businesses, and even litigation that potentially is in the foreseeable future for those small business customers of ours. And so I am delighted to welcome a true subject matter expert on this particular topic, and that is Professor Dorit Reiss from the University of California. Hi, Dorit, how are you?
I'm good. How are you?
Good, terrific. Thanks very much for doing this. I appreciate it. I imagine that your classroom is filled with eager lawyers to be, and we are by no means eager lawyers to be, but we are business people who are always looking over the horizon to see what potentially are the risks that face us. And so we wanted to talk to you about what really is in the future of COVID. But let's start with just, if you could give us, Professor, a brief primer on the kinds of liability laws that you think might arise, or liability litigation that might arise from this last 2 years of the pandemic.
So first, thank you very much for having me. I'm really excited to talk to you and your fellows. As you correctly point out, we've had 2 really exciting years, and much of them had to do with the law. I'm going to focus on liabilities that business might face rather than cases against government. And I think we can think about at least 4 types of suits that we may be seeing. The first 2 are probably going to come under workers' compensation. And those are suits for liability for people who contracted COVID in the workplace, who are claiming the business didn't do enough to prevent liability, to prevent COVID. And we're already seeing some of those. The second are people being sued against employers who imposed the COVID-19 vaccine mandate, for example, or mask mandate, claiming that those measures cause them harm. That will also be under workers' compensation. The third is from business partners or contractors claiming that things the business did related to COVID may have imposed harms on them. Maybe a vaccine requirement made it harder for them to do business with this business, or other things. And the fourth is by customers about either COVID restrictions or lack of COVID measures that led to contracting COVID in the business.
So could you give, that's terrific primer. So those 4 kind of potential areas of litigation, could you give some more detailed examples of what potentially we might see?
Yeah, so here's one example that's going on for the first kind. A worker that at See's Candies is bringing suit against the company saying they didn't do enough to protect her from COVID. And she contracted COVID, and then her husband was infected and her husband died. Her claim would fall under workers' compensation, but the husband wouldn't. So this is going to the regular tort system. And the claim is that See's did not put in place enough requirements, for example, for masking, enough distance between people, and enough other measures to reduce the risk of COVID. Another example we might be seeing, and I know people are already talking about it, is a claim from a customer that said, I got COVID in this facility, and they didn't do A, B, C, and D to prevent that. So here's the difference. The first two claims that fall under workers' compensation, the main question is, do we have harm that can be connected to the workplace? If it's a work-related injury, theoretically, workers' compensation covers it without showing fault. In the tort system, the requirements are a little different. If it's a negligence claim, which would probably be the most common, you'd have to meet the requirement of negligence cases, which includes showing that the behavior of the business was unreasonable, that the unreasonable behavior caused the harm, and a few other somewhat more technical issues. Which means that the business can make a case. We did ABC. We took these precautions. We imposed mask requirements. We sanitized, and our behavior was reasonable as a counter to these claims. So many of these cases are going to be very fact dependent and look at business. As you probably know, it's not only what will the court do, although that certainly matters. Sometimes just bringing a case can be very harmful, and the pressure to settle can be pretty high.
Do you think that this is kind of a rolling snowball? In other words, these first cases that are kind of taken to court, particularly in those first two categories around work that are related to workers' compensation, does one settlement lead to another suit or multiple suits? Do those settlements in turn lead to more suits? Or are we really kind of waiting for an actual case to go all the way through to judgment to provide some sort of precedent?
I think it really matters, as you're suggesting, what happens with these first early cases. If they either settle or end in judgment, it'll be an encouragement to other litigants. Whereas if they get kicked out early, the other litigation is less likely. But I think it's not so much judgment versus settlement, but is there a resolution that's attractive to the plaintiff that's going to matter more than how it ends. I'm also not sure, and this is a question to you, is your audience mostly interested in California law, or would you like me to say something about some things? Because we are seeing, for example, laws addressing this in different states, but not in California.
Well, yes, I would like you to take kind of the continental view, as it were, of across the 50 states, how much variance will there be? And I do seem to remember reading early on that there was a certain amount of laws that were passed to try to protect businesses and enterprises from liability as related to their decisions around COVID. So yes, please kind of take the long view here, the big view and the long view.
You're remembering very, very right. In several states, laws were passed to limit liability for COVID-related infections. And going back to the first part of your question, the states, as with other areas of tort law, are going to vary, which of course creates real challenges for businesses that do business in more than one state. Some states have protections for liability for healthcare workers, but not for business. Others have for business. A significant minority of states, not a majority, has such laws that limit liability of business for COVID. By and large, when they have those laws would not protect, for example, against willful conduct, against conduct that's more than negligent, but will protect against negligent conduct that leads to COVID infection in the workplace. There's, as with a lot of other things for the pandemic, there is somewhat of a political coloring here, with Republican governed states more likely to pass these laws than Democratic. The other thing we're seeing in some states, but not others, that are related is some states are changing their unemployment insurance laws. To make business who fired workers because the workers didn't vaccinate liable for unemployment insurance.
Interesting.
So in some states, we really are seeing business targeted if they impose a vaccine mandate by such laws. California is not one of them. Again, there's a political coloring. These are by and large Republican governed states, but they are making it more costly to impose a vaccine mandate.
So is it fair to say that looking over the landscape of states, that the states that already have laws favoring employees are likely going to be the ones that are also going to have statutes in place that are really going to be supportive of employees as it relates to COVID claims?
That's probably true. Again, with the exception that we're starting to see something, a political divide in relation to vaccines that
Mm-hmm.
might make it more employee friendly for employers to sue if they claim a vaccine injury for
Mm-hmm.
a workplace vaccine mandate. But aside from that, I think you're right that we'll see that employee friendly states have less protections for employers from liability, and the converse, of course.
So, over the last 2 years, we've seen the word reasonable has been under assault. Um, and you mentioned that the defense for an enterprise that's being sued for the steps that it took to prevent its associates, its employees from catching COVID, if they were reasonable. Could you contextualize that a little bit? What do you anticipate is going to be considered reasonable?
So the first thing is, this is where expert guidance can really help. Businesses that carefully followed CDC guidance
Mm-hmm.
and/or California Department of Public Health or the relevant Department of Health guidance
Mm-hmm.
are probably in a much better place than businesses that didn't.
Mm-hmm.
Uh, You might think doing more is always better, and it might be, but as long as you're within expert guidance, it's going to be very hard to claim that you haven't been reasonable. So,
Mm-hmm.
for example, a business that put in place a mask requirement is probably on stronger ground than a business that didn't, and a business that organized for hand washing, easy hand washing, and other sanitation is probably on better grounds as well.
So talk a little bit about we've talked about those two first two liabilities and potential litigation that's related to workman's comp. Let's talk about the other two for each in turn. Can you give some examples of what might play out in each of those categories?
Yeah, so the third category were the contractor and business partners. I don't know of any suits in that area yet, but at least in theory, if you impose a vaccine mandate and it made it impossible for your contractor to work with you, they might potentially bring claims that don't only fall under torts, but also, for example, under contract. You made it impossible to carry out the contract. And conversely, if you have a contractor, let's say, that has people who are immune compromised and you did not take step, you may be facing liability if one of them contracts COVID in your facility. The fourth one, and I'm now not quite remembering, the fourth one is by customers.
Mm-hmm.
Again, I don't know of any specific lawsuits on that yet, and they will face a tricky burden. The tricky burden they will face is causation. To be compensated for a tort, to be compensated for an alleged tort, you have to show that the behavior of the business caused your harm. The problem with COVID is that that's going to be tricky because people can carry asymptomatic COVID and you can contract COVID in more than one place. So you'd
Mm-hmm.
have to have pretty unusual circumstances to be able to tie the disease to the business.
Mm-hmm.
And I can imagine, for example, that a retailer with a customer would face a customer that says, I haven't gone anywhere else. I've
Mm-hmm.
been closed at home. I've been bringing everything online. This is the only place I've gone. That's the kind of case that may go forward.
Mm-hmm.
Other cases really will face serious problem in connecting a disease to a specific business because it's so prevalent and it's hard to show where exactly you contracted it. So the first barrier to those will be causation. The other challenge would be, again, if a business took precautions, that's a much harder case for the customer to bring. Again, so generally speaking, tort liability depends on a bit of bad luck because you have to be injured, but also good luck for the person bringing it because you have to have the right set of circumstances. You don't always have a case. This is going to be true for the COVID cases as well. Sometimes there will be businesses that made mistakes in planning for COVID.
Mm-hmm.
Probably much easier to do at the early stage when we all didn't know what we're doing when
Right.
it comes to the disease. So you'd have to have a combination of bad luck from the business point of view in terms of being the one that the customer can trace the harm
Hmm.
to and having things that can be pointed to. The other thing to keep in mind here is the statute of limitation means that this is going to have to happen within 3 years from the alleged disease.
Hmm.
So if it's happening, businesses will probably know in the next year. The exception is children, but COVID is the chance of a child being harmed by COVID are lower, and the chance of a child being harmed in a business are lower still. So
Hmm.
I think we're more likely to see adult lawsuits than children lawsuits, and
Hmm.
those will have to come up within the next no more than 3 years.
This is incredibly helpful, and there's so much of what you're saying that I would love to unpack with kind of specifics, and I hope I remember all of them as you were speaking. I was raising these questions in my mind. So, the in the case in which a business sent one of their representatives into someone's home, and that representative had, or into someone's place of business, that person had COVID, was asymptomatic, didn't know it, but it's the business service that basically went into someone else's place where they were not exposed and exposed that person. They got COVID, and
Good.
there were consequences to it. Do you foresee that as a situation that potentially arises?
I think that could happen. Again, you'd have to have the kind of luck that fit in the elements of the case. And there's also going to be the second question of the, people come into businesses, and there's an argument that it's the responsibility of the business to take precautions that
Hmm.
even if someone comes in with COVID,
Hmm.
there won't be infection. So there's going to be, in cases like this, there's going to be a real question of comparative fault.
Hmm.
In the business, if someone came in with COVID, maybe whoever sent them was at fault, but was the business also at fault for not taking precautions to
Hmm.
avoid infection if someone comes in with COVID?
Hmm.
Because you can say uh, the person who sent the delivery person should have screened them for COVID, but you, the business, should also have measures when people come in and out to make sure that they don't infect your workers.
Do you imagine there will be any liability around so many, we've all seen so many different videos of just ugly confrontations within a business.
Yes.
Probably the most frequent is ugly situations in airlines. Does the business bear any responsibility for those kinds of, in some cases, violent confrontations that occur inside of their places of business? Because, well, maybe they didn't have a security guard, or maybe they
Yes.
didn't stop it fast enough or intervene quickly enough. Do you anticipate any liability around that?
As we like to say in law, it depends. Uh, this is so here as in other areas, I often feel that COVID didn't actually create anything new that we have to deal with, but turbocharged a lot of things that we had to deal with before. The question of someone being violent in your facility isn't a new one. There's been people attacking people in retail stores, in restaurants, and other places in the past as well.
Mhm.
And sometimes the business can be liable for not doing enough to prevent this or to disentangle it. Businesses don't have a general responsibility to make their place 100% safe. They're not insurers. They're not complete insurers of everybody that comes in, but they do have duties to take reasonable steps for safety. So the question will be twofold. Could the business foresee the altercation? So is it something that was expected? And in that sense, the business would be on much better ground in the first altercation than in the third. Because
Mhm.
after it happens a couple of times, you can say the business should have foreseen it.
Mhm.
And once you get to that, once the business should predict this, what do they have to do? They don't have to do everything to prevent it, but they may have to take reasonable steps. So it's really going to be a case by case question. To give you an example, long before COVID, there was a line of cases of people attacked in parking lots. And the question was, what do businesses have to do to prevent them? California, to give one example, routinely said businesses don't have to hire extra guards, even if there were a previous attack, unless there's something really unusual, because that's a high burden, and the business isn't the police, isn't the full insurer. So the courts are very hesitant to say business should hire extra guards.
Mhm.
But if you have a really high risk, courts may change their views. So it's going to be very much fact specific and case by case.
So flipping it around a little bit, those classified mainly as anti-vaxxers or people who are uncomfortable or feel that there's a health risk with taking the vaccine, but still want access to a place of business. Does the denial of access really represent a liability for a business?
So generally speaking, businesses have the right to decide who they're serving. No shoes, no shirt, no mask, no service is perfectly legitimate. There's some limits to that. And possibly the main limit is going to be for people who are claiming a disability under the Americans with Disability Act. If someone has a valid claim that they have medical reasons not to get the vaccine, in theory, you have to give them a reasonable accommodation. Again, this is a case-by-case question because you don't have to rebuild your business for them. And the question what's reasonable is going to depend. Some of your businesses have no doubt dealt with the American Disability Act issues in other contexts. And they know that, for example, there's guidance for what buildings should be like to comply with the act. But there's a lot less guidance on situations that haven't arisen before, such as COVID-19. And we'll kind of have to feel our way to what exactly do you need to do to accommodate. During the pandemic, in relation to mask requirements, several businesses provided curbside is a service, and that's fine. That's a reasonable alternative to indoors service for people who make a convincing claim that they have a medical disability that prevents masking or prevents vaccinating. But depending on the business, the situation might be very different. And not all businesses are going to be subject to the American with Disabilities Act. It applies to business with more than 15 employees, and it applies to businesses that provide public accommodation that this act defines very broadly. It will include any retail store and any restaurant and anything front-facing, but not businesses that aren't in that category.
So do you think that there are specific categories of business that will have the highest likelihood of encountering COVID litigation?
Yes, and I want to separate here the first two types, which are workplace infections or workplace vaccine injuries, and the second, which are with other people. For the first, I think businesses that have high levels of in-house workplace interaction are going to see more. So we know that there have been cases in meatpacking plants, retail stores that had people come in, or restaurants are going to see more of this simply because people are a lot more likely to contract COVID in the workplace when there's a lot of coming in and interaction. Businesses that could move to remote are a lot less likely to see that. For the second one, they're much more likely to see any of these cases if they have a lot of the relevant interaction. So businesses that have a lot of customers coming in and out, a lot of individual customers, rather than working with larger firms and providing, we'll see more customer lawsuits, and businesses that have a lot of contractors will have to deal more with that.
For those businesses who had a number of employees that were considered frontline workers, who were labeled frontline workers, is their liability lessened by the fact that the government was telling them these people have to work, these people have to come to work?
That's a good question, and the answer is I'm not sure, and here's why I'm not sure. On one hand, this business can say it was reasonable for us to have people in. We were told to do that, and there was a limit to what we could do to protect them if they have to come in and interact with people. There's a limit to, we can require masks, we can try and enforce masks, but there's a limit to how effective that is. And we didn't know initially that cloth masks are less effective. So, and we were told not to use up medical masks. So we couldn't do more. On the other hand, that doesn't exempt the business from acting reasonably. And I'll add one more point in a moment. They still need to take reasonable precaution. And I will add that everything I said now is only going to be relevant to a tort lawsuit, not to workers' compensation. Workers' compensation is no fault. That means that it's not about whether the business did enough. It's about, did it happen? Is it a work collected or not? If an employee contracted COVID-19 in the workplace, uh, and it's covered by workers' compensation because it's a work-related injury, the fact that you took all the precautions in the world isn't a defense because it's not about fault. Workers' compensation is a compromise between employers being dragged to the courts repeatedly and workers not being compensated because proving fault in the courts is really hard. So if you get to the tort system, it's going to be relevant that the government told these people to keep working. But in workers' compensation, it's not.
Interesting. So how, here's as we wrap up, here's the kind of the $64 million question, probably a larger number than that. How big do you think COVID litigation becomes over the course of the next 2 to 3 years?
I actually don't expect us to see a lot of this, even in states that did not pass. And here's why. I think it's going to be hard to connect, even for workers' compensation. You'd have to connect your COVID to your workplace. I think the causation question is going to be hard because of the nature of COVID. And I think many businesses probably have done enough to win on reasonableness, but some won't. I think we may see a non-trivial amounts of cases initially filed, but I think many of them won't get very far. And I think after a while, they'll taper down.
Well, this has been absolutely fascinating. And I appreciate you doing this because I think we all, I don't know how much each of us in our community, at least, imagines how big this will be, or will it be something that, ultimately we'll have to plan and prepare for. But I think you've absolutely clarified a lot of where it will be coming from or where it will be. So it's much appreciated, Professor. Thank you so much for doing this.
Thank you for talking to me.